Welcome to the Exit Rich podcast, where the leading authority on buying, selling, fixing, and growing companies, Seiler Tucker, is dedicated to helping you find the path to retire rich and move on to your next adventure by exiting your business for the desired dream price you deserve. Get ready to exit rich with your host, Seiler Tucker.
Welcome to another episode of Exit Rich. I am delighted today to have my co-author, Sharon Lechter's husband. Yes, they always say there's a better half, a better woman behind every man, but there's also a better man behind every woman sometimes. And Michael Lechter is that man. So Michael Lechter is our guest today, and I'm very excited because one of the biggest things I talk about in Exit Rich, Sharon and Lechter will Exit Rich together. We talk about IP, intellectual property, how to build it and how to protect it. So we have the king of IP on Exit Rich today. So make sure you get your questions in, make sure you get your comments. I will be giving away 3 chapters of Exit Rich to anyone who posts questions, comments, and I read them on the air. So let's go ahead and dive in. A little bit about Michael A. Lechter. He's an attorney, certified licensing professional, and electrical engineer, and guess what? An entrepreneur. So he's an entrepreneur, guys. And I did not know this about you, Michael. You're the best-selling author of OPM, Other People's Money. That's the best thing to utilize. It's the best thing to leverage is other people's money. And how to attract other people's money for your investments, the ultimate leverage, and protecting your number one asset, creating fortunes from your ideas, and co-authored of Technology Entrepreneurship, taking innovation into the marketplace. So Sharon Lechter is not the only author here. Michael Lechter's written some really good books, and I read Other People's Money. Michael is also an internationally known expert in the field of intellectual property, which is why I'm so excited to have him here. His clients have included everything from major software, semiconductor, medical devices, and alternative energy companies to breweries and fast food. That's quite a vast industry there, Michael. I mean, you're all over the place, from software to medical to restaurants and casinos, city professionals, sports teams, from authors to publishing companies, and from startups to venture capitalists to Fortune 100 companies. And Michael is also a venture capitalist, right? You're a venture capital as well.
Well, angel investor.
Angel investor. Okay.
Yeah, I've represented venture capitalists.
So, Michael, welcome to the show.
Well, thank you, Michelle. It's a pleasure to be here.
Thank you. We've met before, and I've got so many questions to ask you. So this is going to, for everybody listening, pack your lunch. Fasten your seatbelt. It's going to be a crazy ride. All right. You're going to drink from a fire hose. So I got to start with, Michael, what were you like as a little boy? Tell me. I know about Sharon's background. I want to hear a little bit about you.
Oh, well, I started out as a child. Grew up in
I love that.
I started out in engineering and went into law. And I've been practicing law since the early 1970s.
Wow.
So I'm an old guy.
Have you practiced different aspects of law, or have you always been driven to IP?
I've always been concentrating in technology type stuff and primarily intellectual property. But intellectual property covers a wide range of things, I assume we'll talk about that.
Yeah, it absolutely does. But you didn't answer my question. What was Michael like as a little boy?
I was a mean little kid.
Were you really?
Yeah, it was. I had trouble staying out of trouble.
Well, how does that serve you now?
Well, it served me well when I was doing a bunch of litigation, but these days I'm much calmer. My wild days are done.
What does it take to be a great litigator?
A great litigator?
Mm-hmm.
To have a great team.
Mm-hmm.
You need to have a lot of good people working with you that can handle all of the details. You need to pay attention to the details. You need to be able to speak from the cuff and be very accurate when you speak, which are really 2 diametrically opposed skills.
Mm-hmm. Were you argumentative when you were young?
Yeah, I was. Not so much anymore.
My husband's always telling me, Michelle, you would have been a great attorney. Because I can be argumentative. So there's so many different aspects in law. What inspired you to go into IP, to intellectual property?
Well, I was actually in the engineering academia. I was going for a doctorate at the University of Maryland, and it had some issues with some of the things that were going on there at the school. And so I took a job doing investigation for a law firm and enrolled in law school.
Wow. You just never know where life's going to lead, huh?
You never do.
All right.
And
So
now,
go ahead.
I'm saying now I'm a cowboy.
And now you're a cowboy. That's right. You and Sharon have that huge ranch that her and I spoke in Los Angeles together, and we spoke about Exit Rich. And I said, Sharon, we got to go out to that ranch. And she's like, anytime you and your daughter want to come. So my daughter loves horses. We need to plan a trip.
Absolutely.
So, Sharon and I wrote Exit Rich together, and obviously you contributed content as well, especially related around proprietary. And proprietary is my fourth P. So I have the 6 Ps. And the fourth P, to me, is the highest value driver. IP, having the right IP and making sure it's protected, can really take you from a 3 to a 5 to an 8 to 10 or an even higher multiple. Would you agree?
For sure. Absolutely. Let me give you some statistics.
Okay.
About 30 years ago, about 80% of the value of the Fortune 500 companies was in tangible assets, bricks and mortar.
Mm-hmm.
Today, more than 95% of the value of Fortune 500 is in intellectual property, intangible assets.
Wow. What did it used to be, Michael? What percentage?
It used to be around 80% tangible
And
property.
now it's 95%
intangible property.
intangible. So let's get that into the notes.
So intellectual property, basically.
And when did that shift? What time frame did it shift in?
It started shifting. Well, it started shifting about 30 years ago, slowly. But we had the reversal probably about 20 years ago.
About 20 years ago.
Steadily higher.
And do you think the internet, Google, social media, all of that also has a lot to do with that?
The data aspects. Now, data is a form of intellectual property.
Absolutely.
And that's the bulk of the value of a lot of the big companies out there.
1,000%. In Exit Rich, I talk about the 8 pillars of IP because everybody's like, oh, proprietary is patents. All proprietary is content. All proprietary is federal trademarks. Well, I say there's 8 different components and maybe even more that I haven't identified that are part of IP. And you know that better than I do, Michael. What would you say is the biggest component in IP that every company should adopt?
The biggest. Let's just sort of run through them.
Sure.
First, information and expertise and data.
Okay.
That can be protected a number of different ways, but that's the underlying intellectual property asset.
So information, expertise, and data, if we can put that in the show notes.
Knowledge. Okay.
And knowledge.
Okay, then there's reputation and trademarks, goodwill. That's another huge component of value.
Reputation, trademarks, and goodwill. Mm-hmm.
Yep. Then there's invention.
Mm-hmm. Invention.
And design, the way things look. Then there's literary works, copyrights.
Yeah.
Okay. And there are a number of different legal mechanisms that you can use to protect these. One is contracts.
Mm-hmm.
You basically create obligations with respect to how people that are given access to your intellectual property can use it.
Mm-hmm.
Okay. Mm-hmm. And that goes hand in glove with trade secrets, confidentiality.
Mm-hmm. Okay.
So if you can keep something confidential, then the bad guys can't acquire it from you. They have to build it, do it, make it themselves.
Mm-hmm. Mm-hmm.
And so you protect the investment that you made in developing the information.
Yeah.
Okay. Invention can be kept as a trade secret, or it can be patented.
Mm-hmm.
Okay.
And you specialize in patents, right, Michael?
I do. I've got there's a separate patent bar that you have to belong to practice patent law before the patent office.
Mm-hmm.
And the main thing is to look at your business and figure out exactly what you've got and really drill down to figure out what the essence of what you have is, the thing that gives you the real competitive advantage.
Mm-hmm.
And and you protect it.
Mm-hmm.
And you use this box of tools, these legal tools, to protect it as best you can.
Yeah, so we want to get into protection. Gina is asking a question right now, one of our listeners. She says, are the trade secrets confidentially the same as a non-disclosure agreement contract?
Okay. The non-disclosure agreement contract is one way to maintain confidentiality. Now, in order for something to be confidential, you literally have to keep it secret, or you create a legal fiction of secrecy using a contract. That's what the non-disclosure agreement does. Now, if anybody has access to information and they're not obligated to keep it secret, they're not out to keep it confidential, then you don't have enforceable rights. So generally, to have enforceable rights, you have to restrict access to the information and have confidentiality agreements. Now, those confidentiality agreements can be in a number of different forms. They can be a non-disclosure agreement, or they can be a provision in some other agreement.
So when you say you have to keep it confidential, when you go to apply for a patent, you have to give out that information, right?
That's right. It's an either or.
Yeah.
You can either keep it secret or try to, or get a patent. Because a patent is a deal between the inventor and the government. The inventor is going to teach the public how to use their invention in return for an exclusive right, the right to keep other people from using their invention for a period of time. It's 20 years from after you file the application in the U.S.
Mm-hmm. All right, so I want to come back to patents for sure.
Okay.
And I like your definition of IP and your different pillars, which are different than mine, actually. Some of them are the same, close to being the same, but some of them are different. So the first thing I always tell my clients is trademarks. You can't just have a local trademark in your state. You really need to hire an attorney. Don't just go on the website. Hire an attorney, check to make sure that name's available, and make sure that you file for a federal trademark, because I've seen time and time and time again, my clients receive a letter from an attorney, a cease and desist letter that says, wait a minute, you have to stop using that company name. And let's say you've been in business 4 years, 5 years, 10 years. And branding is one of the number one things in proprietary, because the more well branded you are, the more I can sell your business for. If you look at Apple, it's worth over $1 trillion just for their branding. Like Michael was saying, 95% of value is those intangibles. Go ahead, Michael.
You hit it right on the head. Trademarks tie your reputation to your goods or services, your products, what it is you're delivering to the public. And I mean, they really represent your goodwill.
Right.
Now, it's kind of funny, but trademarks were the original consumer protection law, going back to feudal times, when the brands, high technology was metal working and leather working. Mm-hmm. And the artisans would put a brand on there so that the consumer knew what level of competency to expect. Mm-hmm. And over the years, the ownership of that right became the intellectual property of the artisan, as opposed to the public. Mm-hmm. Although there's still aspects of that in present day trademark law.
Right. So so not protecting your trademarks, getting those federal trademarks, can kill your brand and literally put you out of business overnight.
Yeah, what you were talking about, the trademarks have, at least in the U.S., have two components. Mm-hmm. There's a common law component, and then there's the federal component. You get common law rights to a trademark just from using it. If you're the first entity to use the mark with particular goods or services in a particular geographical area, and this is the local thing that you were talking about,
Mhm.
you can get the exclusive rights to use that mark with those goods in that area.
Mhm.
But if there's somebody else out there in a different area that doesn't know about you and they start using it, they get the rights in that area. I mean, do you remember when
But if
SO
they applied for a federal trademark, Michael, then they could literally put you out of business.
they could conceivably wipe you out everywhere but the little area where you are working, where you have a market
Right.
uh, at the time they file. So they would basically foreclose you from the rest of the country.
I always tell my clients, make sure you put that TM behind your name. Number one, check to see if it's available. Put that TM and then go ahead and file for the federal trademark. It's not that much money to
Amen.
protect your company name and your company brand.
These days, I would recommend that you file even before you start using it. It's like you say, it's not that expensive.
Mhm.
And in the old days, you had to actually use the mark before you could register it. That law changed about a decade or, I guess more now ago. You can get rights to a trademark by filing a federal registration based on your intent to use that mark in the future.
Right.
And then once you start using the mark, you get your rights relating back to the time when you filed the mark. And again, it's priority of use. Whoever uses it first gets the rights. And when you file that registration and ultimately start using it, it's as if you started using the mark when you filed the registration.
Right.
So, and that would give you statewide or United States wide rights. Now, trademark rights are geographic in nature. So
Mhm.
you would have to go to other countries to get rights there.
But you could get a federal trademark for the United States.
Yep.
And then if you're planning to expand globally, then you got to get those trademarks per country, or there's another word for it, I forgot, where you can get a global trademark.
Well,
Um,
there are treaties that let you file in other countries, and then there are certain countries that certain groups of countries like Europe, you can get a European trademark.
okay. All right. Well, we have a client that's operating all over globally, and I forget the name of it, but there's something where you can apply for, and you can pretty much get the trademark in every country. It's very expensive and very time consuming.
There's something called the Madrid Protocol.
That's it, the Madrid Protocol. Thank
The
you.
U.S. subscribes to, and you can go through the U.S. Patent Office and basically apply for rights in a bunch of other countries, all
Right.
the other Madrid Protocol countries.
Right. I agree 1,000%. All right. So we're talking about branding, which is IP. The more well branded you are, the more your company will sell for. We talked about federal trademarks. Let's go ahead and go back to patents, because anybody who's ever walked Shark Tank, what do they ask? Do you have a patent on that? Do you have a patent pending? Do you have a utility patent? So let's really talk about patents, because so many so many investors, so many buyers will buy a business. Like, we sold a business for $30 million that was losing money, but they had 18 patents. So patents are extremely valuable. And a lot of clients are like, well, Michelle, what do I have that I can patent? What kind of patent do I get? Can you get a patent for a service business? So can we kind of dive into patents a little bit?
Absolutely. Okay. I mean, patents are a demonstrative asset. I mean, if you've got a patent, then you know, and you can show people, you wave that patent around and they know that you have rights to the invention.
Right.
Okay.
Now, that
So,
doesn't mean you're not going to get sued or somebody's going to go after you, and you have to sue them to
yeah,
protect
I
your
mean,
patent.
and that's part of the beauty of the system. It's designed so that there's an incentive to make improvements.
Right.
So just because you have a patent on something doesn't mean that you can necessarily use it. But in any event, the patents are worth their weight in gold.
So,
And
so Michael, like, there's a lot of companies, even my own, but there's a lot of companies who are like, okay, what can I patent? How does maybe somebody has a conversation with you and that's the first step, but how does somebody look around their company and say, what can I patent here? What can I create for a patent? Because we know patents add huge, huge value and get a much higher multiple on a sale of your business. You literally go out of business and sell patents. So how does business owners kind of entrepreneurs look at their business and say, oh, I think I can patent this?
okay, well, many times, the basic mission of the business is to serve a particular need or solve a problem.
Mm-hmm.
And the solution to the problem or the way that you're meeting that need is something that you would want to look at right off the top
Mm-hmm.
to see whether or not it's patentable. And if it's not patentable, whether there's some other way to protect it.
Mm-hmm.
I mean, coming in after the fact, you really want to take a look at your business and dissect it.
Mm-hmm. Agree.
It's giving you that competitive advantage.
Mm-hmm.
And keep drilling down, because many times you'll encounter a problem in your business, or you'll come up with a more efficient way of doing something in your business.
Mm-hmm.
And it may have application in businesses totally unrelated to yours. And if you can take the blinders off and get to the essence of it, and you patent it broadly enough, then you can license that into the other industries without affecting your core business.
Mm-hmm.
You still have your production, and you've got an additional stream of income coming in from the licensing.
Mm-hmm. And sometimes it's hard to see if the forest through the trees. So sometimes, many times, I think an entrepreneur needs an outsider's perspective, a professional like Michael Lechter, to really look at your business and say, gosh, did you think about this? If you just made a few tweaks here, you could patent this. Does that make sense?
Yeah. And you go to your customers, see what it is about your products or your services that they like.
Mm-hmm.
And then you figure out, well, what is it that makes them do that? What makes the product give that? What feature is it that provides the thing that they like? And what
Yeah.
makes that feature work? And you just keep drilling down and try to get protection at the most basic level.
Can you talk about the different types of patents, Michael?
Sure. Generally, when people talk about a patent, they're talking about a utility patent.
Right.
And that really covers the way things work, physical things, physical processes, things that are, well, I guess the Supreme Court said anything under the sun made by man is patentable as long as it's new, it's novel, and it's not obvious in view of what the public already knew at the time when you're filing the app. There's also a design patent
Mm-hmm.
that covers the way things look, the ornamental features,
Mm-hmm.
anything that's not functional.
Mm-hmm.
Now, a given product can have functional aspects that would be covered by a utility patent and non-functional aspects that are covered by a design patent.
Okay. And what is like very, very difficult to patent, if not
Well,
impossible?
the,
A process is very difficult.
well, physical processes, not so much. I mean, they are patentable just like everything else. But
Okay.
as soon as you start getting into the realm of mental processes, things that don't create any sort of tangible result, then you start running into difficulties because you can't, as a practical matter, you can't keep people from thinking through a process. And if it's just a business process that happens in somebody's head or a mental or a mathematical algorithm, then it's not considered patentable.
Okay.
Now, if it's applied in the context of a physical process, then it is patentable if it's new and not obvious.
Okay. Makes
Now,
sense.
now there have been some companies that will file patent applications, at least in the old days, on anything that was new, and they left the question of obviousness to the patent office.
Mm.
Today, the expenses are a little bit higher, and so there are fewer and fewer companies that do that.
All right. So we talked about design. We talked about utility. Any other patents?
There is a plant
Process. A
patent
what?
a plant patent that relates to certain types of plants.
Okay.
Not something that I've done a whole lot in, and I keep forgetting whether it's the type of plants that grow from cuttings or whether they're seeds. And there's another type of protection for whichever type plant it is that's not covered by the plant patent.
Yeah. You can also patent your seeds, right? So if you're growing,
Okay, so that would be it.
patent your seeds. Okay. Anything
And
else?
even now, and there's a lot of work on genetically altered
Mm-hmm.
seeds and animals. There is a patent on a genetically changed mouse. that it's more susceptible to certain types of cancers.
Wow. So the most common in businesses are your utility patent, your design patent, and you said a process patent, right?
Yes. Well, the process patent really is under the umbrella of utility patent.
Understood. Okay. Wonderful. Gina has a comment. She says in 2012, the government changed the law on intellectual property via patents. There is a grandfather clause for certain intellectual property rights before the law changed. Can he explain this clause? Can you explain this clause?
Well, yeah, I'm going to give it kind of short shrift because it could take an hour and a half to really go through it. But what it was.
So we'll have you back on.
The people will get really bored once I get into the nitty gritty of it. The basic thing was they changed the term of the patent. The patents used to start when they were issued by the patent office. You filed an application, you in effect, a patent application is basically a proposed patent. If it gets, everything's good with the patent office, it's published, the patent is word for word what's in the application. Okay, and you file the application and you negotiate with the patent office over the scope of the patent. There are two basic parts. There's a written description. This is what the inventor is giving to the public, and it has to have a certain level of detail. It has to be in enough detail so that the typical people that are in that industry can actually make and use the invention. Okay, and then there are the claims. The claims define the scope of the invention. They're like a one-sentence definition of the invention. Of course, that sentence can have some really weird punctuation and indentation, and it can be a page and a half long, but it's one sentence. That you infringe the patent if you have the equivalent of every element, each and every element that's in the claim. If you're missing any element, you don't infringe. If you have additional elements, you still infringe. So if I have a claim that says a gizmo comprising A, B, C, and D, if somebody has A, B, and C, but not D, they don't infringe. If somebody has A, B, C, D, E, F, G, they still infringe, even though G may be patentable in and of itself.
Okay.
That's where the improvements come in. Okay, with that background, before 2012, the term of the patent was 17 years from the issue date of the patent, when the patent office said, hey, it's patentable, we're going to grant your rights. So then you had 17 years of exclusivity. Okay. The applications that were filed after the effective date of that act then had a term that was 20 years from when you filed the application, as opposed to when the patent was issued. And the reason that they did that was there were some people that were taking advantage of the patent law, and they were filing series of patents that related back to the earlier filing date. And so if they were issued, 20 years after they filed the application, and they were judged, their patentability was judged based on when they filed it, and they were filing claims that were more or less described, supported by the description, but the new claims were designed to cover new developments. Anyway, because people were doing that, they changed the law.
Gotcha. Okay.
So there are other changes. There are things that are prior art. That was prior art that is no more, and there are things that wasn't prior art and is now. So.
Okay. Gina says, come back on. Yes, come back on. I won't be bored. I think Gina likes all this. So, I mean, it's very interesting. And I've talked to many different attorneys. My clients have talked to many different attorneys, and you get a lot of different answers. So if somebody's out there is looking for patents, I suggest you call Michael, because he's been doing it since 1977, I think he said. So you really need an expert to go down this path with you. But I will tell you, it can exponentially increase your value. We've got a few other questions on here. Let's see. We have Kaylee that says, what are some common mistakes I can avoid making when it comes to intellectual property? And that was a question I was going to ask you too, Michael. What's the biggest mistakes? What's the biggest case studies and nightmare stories that you can share with us when it comes to intellectual property.
Okay. And these go hand in glove. Okay. The biggest mistake you can make is not laying the foundation, not taking the time and going to the expense, even when you're a startup and with limited resources. You've got to lay the foundation. You have to have the right type of intellectual property protections in place. You have to have the right type of agreements in place. You don't necessarily own what you pay for, particularly if you have non-W-2 employees. Okay, the biggest glitch that comes to mind goes back to a software program that, in my view, created the age of the personal computer. It was a spreadsheet program. It was the first program that let you operate on data in a spreadsheet format. And before that time, really only us geeks were using computers. There really wasn't a reason for most business people to use them, or personal computers. And once the spreadsheet came out there, suddenly computers became relevant to the business people that are out there, became widely relevant. Okay, so you all are familiar with Excel, I'm sure. Okay,
Yes.
I'm not talking about Excel. If you remember Lotus 1, 2, 3. Okay, I'm not talking about Lotus 1, 2, 3.
Okay, you're just dating me. I'm dating myself.
Well, my mind just went blank. Artisoft was the name of the company, and
I think we need to patent your brain.
anyway, there were two inventors. There were guys out of the Boston, I think, and they decided it was too expensive to file a patent application. I'm having one of those moments. The name is just escaping me. I mean, I'm thinking Artisoft or anyway. I'll have to
Aerospace.
No, it was well, anyway. So they decided it was too expensive. One of the guys' name was Dan Bricklin. That much I do remember. And they didn't file the application. And years later, after the industry was able to legitimately appropriate all of their basic work, and they made the market, but other people came in and were able to take it from them.
Yeah.
The Lotuses, the Excels,
Yeah.
because they didn't have a patent. So Bricklin was being interviewed, and I've forgotten what the context was, but the moderator asked him, "Do you think it made a difference that you didn't file a patent?" And he just sort of leaned back in his chair and looked at the ceiling and said, "Gee, only several hundreds of millions of dollars." And that was the fact. Had they gotten the patent on their product, and back then they could have, they would be in the position of a Microsoft today.
Okay.
So that's the horror story.
There's lots and lots of horror stories. I see it every day with people not protecting their brand by getting those federal trademarks, contracts. You talked earlier about contracts. Contracts are definitely proprietary, especially if you have employment contracts, most importantly, client contracts. But the biggest mistake the business owners make around contracts is not having that transferable language. So I think Michael and I could talk all day, and we can bring Sharon in too and talk about the biggest mistakes that business owners make when it is surrounding.
The terms of the agreements definitely make a difference.
Yeah, because if you don't have that transfer, so let's say you've got thousands of clients and it's an asset sale, which 99% of all sales are asset sales in my experience of over 23 years. And if you don't have that transferable language, then your deal can stop in its tracks because those contracts are not transferable to the new owner. And in 23 years of doing this, I've seen where two owners actually got this right. And so what happens is you have to go out to your clients and get them to sign a consent to transfer agreement. Now they know your business is for sale. So you need to, again, we're talking about all these assets, federal trademarks, transferable contracts, protecting your brand, getting those patents, and protecting your intellectual property. Because like Michael said, it's either confidential, which is hard to do, or go out and get a patent for that.
Yeah. And I have seen vendors hold the company up and would not agree to assign their agreement to a potential purchaser, and it blew the deal.
Well, and you're right. You just said something different. You said vendors. I said clients. And there's vendors too that you need to have those transferable contracts. We once sold a business for 165% more than what the business valued at because it was in the oil and in the energy space. And it was a very similar company with similar products and services, but different. My client had a bunch of patents, and they outbid everybody else because they wanted that BP contract. But guess what? It was not transferable. They took a huge risk, Michael, went ahead and purchased the company in hopes that they would get that BP contract because they've been in business for decades and been trying to get their foot in the door with BP and never could. And this company could do it for them. And we couldn't get the consent to transfer, even though the seller went over there begging the lady. He even got on one knee and proposed to her, bought her flowers and chocolates and a ring. I still couldn't get her to agree to do a transferable contract. So this IP is so important, and there's several different pillars of IP, like Michael discussed and like I'm discussing. Lawson wants to know, can you provide examples of industries where intellectual property is crucial for success?
Okay. Generally, anytime you've got a startup, you can't compete with the big guys unless you have some competitive advantage. And unless you have intellectual property protection of that competitive advantage, the big guys can just come in there and appropriate it, just like they did with that spreadsheet program I was talking about.
Right.
So when you're small and you don't have that market power, it's that's where having the intellectual property is absolutely critical. It's the great equalizer.
So Lawson also asked in a follow-up question, I just started my own startup, which means I have limited resources and money. How do you approach the challenge of protecting intellectual property for someone like me and getting that patents and getting those, those trademarks, etc.? So how does a startup have the funds to do that? I mean, it should be built
Well,
into their working capital, but
sometimes there are attorneys out there that will provide services for equity. Now there are some ethical issues that can be waived, because there's a basic conflict, a potential conflict, I should say, between the attorney as a shareholder and the attorney that's providing services.
Mhm.
But you can do that. Sometimes the attorneys would be willing to operate on a profit sharing type of a basis up to a certain point. I mean, there are a lot of things that can be done, or you can team up with somebody that does have the resources to get the legal counsel that they need.
Wow, that's great advice.
Okay, so Sharon likes to talk about the association. I talk in terms of teams. I mean, business is a team sport, and every business needs certain resources to accomplish its business goals. Sometimes those resources are cash, but there are other ways to get to the resources besides raising the cash and buying the resources. Sometimes you can go directly to the source of the resource and work some sort of a deal, whether it's for equity or for services or whatever your imagination, whatever you can negotiate. And most of the time, you end up in a better position than you would if you just raised the money and went out and bought the stuff.
Yeah, I agree, 1000%. But we're talking about crossing the T's, dotting I's, crossing the T's, and planning out your foundation. And this is what Michael's talking about, because so many business owners start out on a string shoe budget, and they're living, they're funding their business with very little to no money, but then they never go back and put these proprietary assets in place. And like Sharon Lechter says, assets are sexy. So we got to make sure we go back and protect this IP. But you just kind of transitioned, which I wanted to transition into your book, Other People's Money. And so it's always better when you use other people's money, as long as it's not high interest or you're giving up a huge percentage of your company. Tell us a little bit about your book, Michael, Other People's Money, and how that's helped a lot of clients.
Well, it really relates to building a business and using alternative mechanisms than just going out there and raising capital. We go into the science of raising capital and making sure that you don't raise too much too early when you're talking about equity. So you
Say
can
that,
raise.
say that one more time. Make sure you don't raise too much too early. That's a huge mistake that a
Yes,
lot of entrepreneurs make, and they give up their company.
that's right. And they do that because it's easier. I mean, you should have a business plan, and that business plan should tell you when there's going to be big upsticks in the valuation of your company. So certain events will happen that will make your company much higher value. You get that first working model, you get something on the marketplace, you get your patent. There are many different events that will cause that uptick in valuation. And you want to raise just enough money to get to that point. Now, you want to give yourself some slop because my experience is you're always wrong as to how much it's going to cost. It's always going to be more.
You
But
mean like a general? Well, you mean like a contractor says it's going to cost this much to build your house or do a build out on your business on your real estate, and then it always seems double or triple the price they quoted
yeah,
you.
that's pretty much it. Only this time you're contracting with yourself in effect. You
Right.
know you think you know what it's going to cost to get to this certain point. And generally, I just as a rule of thumb will add a third onto that. So you raise that much money. Now, the lower the value of your company, the more equity you're going to have to trade per dollar.
And I should do a safe note, right? You could do a safe note, Michael.
I'm sorry, say
A
again.
safe note. A safe note.
Oh, say well, the uh, taking a loan is a different animal, and if you can qualify for the loan,
No, I was
that
saying a safe note where because I just did this with someone. A safe note where is you sign a note. Unless I want to invest $150,000 into a company, I sign that note. No equity exchanges hands. When and usually there's a good rate to get in where it's very low. And then when there's an event like raising more capital, selling a company, whatever, then the investor gets paid that market right. I'm not an attorney, so I don't know all the ins and outs, but it's called a safe
yeah,
note. And that's
okay,
what a lot of people are using these days.
that's a different term that than what I've used.
Well, you
There's
probably have the right term, the right name.
convertible notes where you make a loan and you have the choice, or someone has the choice, depending on the way that typically the investor, to convert that money into stock or units, equity units at a certain price at the due date, whenever that is. And there are a zillion different ways that you can set those up.
Okay.
But most of the time, when you have people going out and they're raising money by selling pieces of the company. They're selling equity in the company, and that's where the founders run into trouble because they end up selling the company, and their percentage of the company is very small after they've done a couple of successive rounds of funding.
Right. I've seen that time and time again as well. And so does your book, Other People's Money, does it cover lots of different strategies in there about how to raise capital without giving away the farm?
And there are different business models that you can use. Instead of going into a manufacturing type business where you're doing everything, you may go into a licensing business where basically you're developing the intellectual property, and then you're licensing other people that already have the infrastructure, already have the machinery to
A lot less
use.
headache.
It is. And
A
then
lot less headache. And it can be very lucrative because I talk about licensing deals all the time on Shark Tank.
oh yeah, and particularly, if you have something that spans a lot of different industries, the intellectual property, and you can pick and choose and license somebody just to use your intellectual property in a particular market channel or in a particular industry or a particular product line, and you can go to somebody else that has a better presence in a different channel or industry and license them. So it's there's lots of flexibility, and you can create many different streams of income.
Right. And you can do that with franchising too. Use other people's money with franchising to expand your brand.
That's right. I mean, franchising is kind of a combination of trademark license and trade secret license or patent license.
Mhm. Yep. Gina says, I worked with investors on my invention and obtaining patent in the process. I signed one or two contracts. I signed the first. It stated if I go to, wait, where does it go? Okay.
Okay.
Right.
Yeah.
She keeps sending me stuff and then I miss it. So it says I signed one or two contracts. I
Yes.
signed the first. Oh, you see that, Michael?
Yep, I do.
It's,
And this
well,
is
let me finish reading it so
we're
the whole
told-
audience hears. I want just the whole audience to hear the question. I signed the first. It stated if I go to shelf, I'll owe 10% royalties to them. Is this reversible?
Okay, I didn't see is it reversible? Well, the question is what the contract says, whether it's reversible or not. This is what I refer to as a profit interest. So you've got investors that are contributing money to the company, and in return for that, they get basically a royalty on each item that's sold. I think that's what she means by go to shelf.
Yeah, she says when I go to shelf. Yeah.
Yeah, so that's one way of financing a product or a business. Now, whether or not that can be reversed depends on what's in the contract. Now, generally, there's a limit as to how much money they collect. So they're going to get this 10% until they reach a certain amount of money or a certain time period for a certain time period. But if you didn't have, no, I shouldn't say it that way. There's no rule that says that there has to be that type of provision in the agreement. And if it's not in there, then as long as you're selling that products that are covered by the patent claims, you're going to end up paying that royalty to your investors.
She said, and then she says, even if I were to invent without those investors, I still owe 10% royalties. So even if she invented without those investors, she still owes 10% because of the contract, I guess.
I guess I'd have to look at that contract.
Well, there you go, Gina. Send him the contract. Engage Michael. Yeah.
Anyway.
So yeah, so you'd have to look at the agreement, see if there's any loopholes, see if there's anything that you can do to help her.
Yeah, so I mean, it may be they put the money in and they're going to get 10% of whatever of gross or net or whatever the agreement says. And I have seen that type of agreement before.
Well, Gina, did they invest any money? Because she says, even if I were to invent without these investors, I still owe 10%. So that makes it sound like the contract calls for the 10%.
Like I said, I'd have to see exactly what the situation was there.
Okay, well, that makes sense. So at the end, you're going to tell everybody how to find you. But one thing I really want you to mention is, look, attorneys, doctors, bankers, M&A advisors, every different industry experts out there have different opinions and different contracts and etc. So how does everybody protect themselves? How do entrepreneurs protect themselves? How do entrepreneurs make sure that they have the right attorney? How do they make sure they do their due diligence before they get caught in a trap like Gina has now? And so what do you recommend to prevent that? Because I've been burned by different attorneys. There's CPAs out there, and how can someone protect themselves to make sure they don't get stuck in a situation like she did?
Get as many recommendations as you can.
Yeah.
You speak to other clients, although sometimes clients don't really know whether the attorney's done a good job or not, because unless there's some sort of a contest, a dispute, nobody even looks at agreements or.
Well, that's right. That's right. And entrepreneurs get so excited to patent something, to do something unique in their company that they find an attorney. They don't really do their due diligence. They don't call references because like, oh my gosh, he knows what he's doing. Boom, let me sign on a dotted line. And then I'll get a second or third opinion. It's like if a doctor told you, you are about to die in a week, you're going to go get other opinions, I would assume. And so it's kind of like the same thing, go ahead.
Yeah, I mean, exactly. You want to get lots of references. Talk to clients if the clients let the attorney give you their name. Now, if you can't get any sort of references, if you don't have any other data to judge on. I would just go to the biggest firm in town that has an intellectual property section and the business law section, corporate finance for a small company. And if you have a litigation section. I used to get local counsel for litigation. I was handling all around the country. And there'd be many instances where I didn't have a recommendation. I didn't know anybody in that particular area. And so that's what I would do. I just go to the biggest firm. Now, that doesn't mean they're necessarily the best, but if you don't have anything else to go on, there's typically a reason why they're big. Now, they may
What if
be
you
more.
don't have the fees? What if you don't have the money to go to some of those biggest firms that are charging $700-800 an hour?
Okay, well then, that's a consideration. They're going to be more expensive.
Yeah.
And having somebody, if you can get a bright young attorney, you may have to pay for more time than it would somebody that has more expertise, but you may get as good a work product.
And a lower rate. At a much lower rate.
It balances out because somebody that has more expertise may well be able to do
quicker.
Quickly. So,
yeah.
But there are a lot of things that expertise, it isn't really going to play in how long it takes. And having a firm that's got a bunch of different attorneys at different levels and where you can assign the right level attorney to do different types of work can be a whole lot more economical. And
I think what you said earlier is so important. Find a firm that has an IP department, has a patent department, has this, has that. Because so many times entrepreneurs will just go to their general attorney, or I've seen them go to a personal injury attorney, and they'll go to different attorneys. Like I was using an M&A attorney, an M&A firm, to do all of our trademarks, and they charged me a fortune, even though I sent them a lot of business, and they did it all wrong. So you got to make sure you're going to somebody that specializes in that industry. If not, you're wasting money, you're wasting time, you're wasting energy because they're probably not going to do it right. So you got to make sure you hire that firm that really specializes in that particular industry. Like I have a firm right next door to me that specializes in IP, but they also do M&A. But you want to make sure that you're not, it's like you're not going to go to a chiropractor if you need a heart surgery.
Well said.
All right, Michael, you've been a great guest. It was great golden nuggets, as we talk about in Exit Rich, or golden nuggets. What last minute tips can you leave with our listeners on IP, intellectual property, why you should have it, how you should protect it? Any last minute thoughts here?
Okay, well, let me just sort of restate and summarize. Okay, you want to make sure that you get that foundation in place. Start out with a plan to protect your intellectual property. Look for opportunities to create intellectual property assets. Look for problems that you solve. If you solve a problem and that solution is significant, it's going to have value. It'll give you a competitive advantage, and your competitors will want to use it, so you want to protect it.
Correct.
And you apply the intellectual property law mechanisms to protect it. You trade secret protection, the contracts, you register your trademarks, register your copyrights.
And make sure too, if you have 1099s and independent contractors, that you get them to sign those agreements that you own the content.
Yeah, let me tell you another horror story. Do you remember the Where's the Beef commercial for Wendy's?
Of course, my daughter, when she was 5 years old, she was regurgitating that commercial.
Wendy's was very proud of that commercial, and my firm represented Wendy's. And they were bragging about how much money they were making by virtue of that commercial, right up to the day they were sued for copyright infringement.
Ooh.
And it turns out that the gentleman that they hired to produce and direct that, a guy named Saddlemeyer, had done an essentially identical commercial for another outfit called Suburbia 10 years earlier. Wow. And I mean, it was strikingly similar. I mean, it was basically the same, except instead of having three little old ladies go up to a counter and say, "Where's the meat?" They had "Where's the beef?" Three little old guys went up to the counter and said, "Where's the meat?" Camera angles were all the same. The backgrounds were all the same. I mean, it was striking.
But it's the guy that they hired that created that very similar commercial.
That's right. So And he had been hired by another outfit before, and he gave them that same commercial. Well,
so who got sued? Wendy's got sued, or the guy they hired got sued?
Suburbia sued Wendy's for copyright infringement, and we were able to get it thrown out on summary judgment because the agreement that Suburbia had with Saddlemeyer just said that he was going to provide them a commercial for their stuff by such and such a date, and they were going to pay him so many dollars. It did not specifically have any language in the agreement that said that he was assigning the intellectual property rights, the copyrights, to Suburbia. Now, we were talking earlier a little bit about how you don't necessarily own everything you pay for. Just because you pay for something doesn't mean you own it. And copyrights are one of those things. Unless there is a written agreement, if you hire somebody that's other than a W-2 type employee to provide you copyrighted material, copyrightable material, so that would be content, that would be photographs, that would be websites, anything like that, unless your agreement specifically says that they're assigning you all of the copyrights, they own it. The contractor owns it, not you. Mm-hmm. And that was the case with Suburbia.
And that could be the case with the Fiverr and Elance and Odesk, any of those companies that are producing logos and graphics and work and Yeah,
you hire a graphics person to give you a graphic, and you, at best, unless you've got language of assignment in your agreement with them, they retain the rights. Yeah. You'll get a limited license to use it. You can use it for one particular thing, nothing else.
And it doesn't really blow up until it's like a big company like a Wendy's.
That's right. That's exactly right.
Yeah. So you see, y'all, why you need a good attorney, because there's so many little hiccups that can happen along the way and mistakes that can be made because people don't think about this stuff. It's not your business. That's why I always say, focus on your strengths, hire out your weaknesses. So, Michael, with that being said, how can everyone get in touch with you and get your book, Other People's Money, and your other books?
Okay. Well, my books are available on Amazon or through Sharon's website, SharonLechter.com.
And just in case y'all don't know who Sharon Lechter is, which I find that I don't think that's the case, but Sharon Lechter wrote Rich Dad Poor Dad, and the Robert Kiyosaki series of Rich Dad Poor Dad was, I don't want to say too much, but she was big in the Rich Dad Poor Dad series. And so that's Sharon Lechter. She is wonderful, wonderful, wonderful person. And I'm sure you would agree.
And she co-authored Exit Rich.
She is a co-author of Exit Rich. Absolutely, 1,000%. And Michael also has some content under proprietary section, which is our 4th P, by the way, and some great content. So go get Exit Rich too. But Michael, how so they can get in touch with you, get your books through Amazon, and then they can go to Sharon Lechter. Say that website one more time.
SharonLechter.com. Sharon, LECHTER.com.
Yep. So if we can put that in the show notes, that would be great. Michael, you were a wonderful guest. So excited to have you, and you dropped a bunch of good bombs there that people don't really think about. People don't really know because, again, it's not your core competency. It's not your area of expertise. That's why you have to hire the experts. So I encourage everybody to reach out to Michael Lechter. Thank you so much, Michael. And thank you so much for all of my listeners. Thank you for all of my listeners for tuning in on another Wednesday to hear all these golden nuggets that we bring to you every week. If you haven't subscribed, please do so. And please share this episode with all of your fellow entrepreneurs, anyone in your network, because I know that they can get great information, real information from an expert in this industry, Michael Lechter, and this can help save your business. So go back and listen to this again and again and again. I'll see all of you next week. Gina, thank you for your questions. Lawson, thank you for your questions. Reach out to me. We'll send you 3 chapters of Exit Rich. Thank you all so much.
Thank you so much.
Thank you.
Thanks for listening to the Exit Rich podcast. Don't forget to check out Michelle Seiler Tucker's Build to Sell Blueprint books and Exit Rich, along with more blogs, videos, and resources at exitrichpodcast.com. Be sure to connect with Michelle on Facebook or LinkedIn and stay tuned for her next episode by subscribing in your favorite podcast player.